Hold up, we're only 10 seconds in, and the judge is already calling out Mr. Rhino's courtroom fashion sense. Pro tip: when a deputy tells you to dress for trial, it's not a fashion suggestion, it's a legal obligation. This isn't a pajama party, it's a felony trial.
Judgments from past hearings he's had and held, and we were provided those today. One of them, and I had received already one. I discussed that with my client, and he kind of doesn't like the way I'm approaching everything, and doesn't like the way or he feels that I'm not representing him accurately.
Mr. Rayner, come on down.
So we might want to talk to him because he's asked me to get off the case. And I told him, that's something you have to discuss with the judge. And for the record, we have been relayed an offer to my client.
All right. So, Mr. Rayner, are you Mr. Rayner?
Yes, miss.
All right. So it appears to the court that you do not want to come dressed.
Whoa, did you catch that? Mr. Rhino wants to fire his attorney right before trial. Let me ask you, would you change drivers mid-race? Probably. Not. This moment right here sets the tone for a clash of trust, strategy, and courtroom patience.
For trial when you're supposed to be dressed for trial.
Well, believe it or not, Miss Boyd, I wasn't aware of this trial in the first place. And
no, because here's the thing. Firstly, when a deputy at the jail tells you you're supposed to be dressed for trial, you're dressed for trial. And when your time, you were told before and you didn't do it. And guess what? If you ever come back to this court where a deputy at the jail has told you to dress for trial and you're not dressed, you know what's going to end up happening? You're going to be going to trial in that red jumpsuit. And you know why you're going to be going to trial in that red jumpsuit? Because it's going to have been your choice. I am not having you come back to this court again where you're pretending as though nobody told you you had a jury trial. The other thing, you're saying that your attorney is telling me that you want another attorney?
That's correct.
All right, then you need to hire one. Do you understand?
I don't have any support issues. Support at all as we speak right now at the moment.
But support for what?
Ordinary to hire an attorney.
Oh, well then this is your...
And here comes the real bombshell. You want a new attorney? Cool, go hire one. Translation: public defenders aren't menu items. In many courts, you don't get to shop. For a state-funded lawyer like it's Amazon Prime, you get who's qualified. Period.
Attorney. This is what I've discovered, and I've told many people this before. This is what ends up happening. When you, as a defense attorney, are placed to represent somebody and you've been appointed to represent them, number one, there are certain qualifications that you must have. This is a third-degree felony. It may be bumped up to a second-degree felony based upon what's in the indictment. This attorney would not have been appointed to your case if he didn't have the qualifications to be on this case. I don't allow attorney shopping in this court. Whoever comes up on the wheel, that's who your attorney is. The state will tender an offer to your attorney because I require the state to tender an offer. State can make an offer and say, we're offering 20 years. The state can say they're offering the maximum. Guess what? Your attorney has absolutely, really no control over what the state is offering.
So what's
even if your attorney were to go to the state and say, well, these are the weaknesses in your case, and this is what my client is willing to accept, the state can still say, I am not going to offer your client what he wants. The only thing I will offer you is A, B, or C. And your attorney ethically is obligated to tender that offer to you. Now, you can accept it or not. That's completely up to you. There are certain rights you have when you're charged with the offense. One of them is whether or not you will accept an offer or not, and whether or not you will testify at trial, and what plea you will enter. Do you understand? So you're not getting another attorney. If you want to hire one, you are more than welcome to hire one. So this is your attorney. Next question.
Why does my case carry at least prison time and not probation?
Here's the
or
thing.
anything?
Boom. Decision time. The judge just laid out the core of criminal law procedure. Offers, pleas, rights, this is the meat and potatoes. And remember, just because the state makes an offer doesn't mean it's negotiable. The defense can suggest a counter, but it's not a haggling booth.
You will have to speak to your attorney. What I can tell you is there are certain cases, number one, that you're not eligible for probation. There are certain cases that if you go to a jury trial and if you are found guilty, you're not eligible for probation. There are some cases that if you go to jury trial, maybe you're eligible for probation from a court. But I cannot tell you whether or not, just based upon looking at your case, which would be the indictment for me, whether you're eligible or not. What I can tell you though, usually if you have a repeater count and you go to a jury trial, you're not eligible for probation. So you need to speak to your attorney about that. And I'm sure your attorney will tell you whether or not you're eligible. Think of criminal history this way. If you have somebody that you loan money to, right? Let's say somebody comes to you and they say, can you loan me $50 and I'll pay you back next week? And you say, yes, I will loan you the $50. What are you going to use it for? Oh, I got to pay my electric bill, which that would be a good electric bill these days. And that person gets the $50 and they don't pay you back. And you just, you said you pay me back on this day, you're not paying me back. That person comes to you for a second time and said, look, I'm in dire straits. They're about to cut off my electric bill. I need $60. And you tell them, you know what? I gave you $50 just last week and you never paid it back. And they're like, I know, I'm so sorry for doing that, but I promise you this time I will pay it back and I really need the $60. So you loan them $60 and they don't pay it back. And then they come to you for a third time. You may say, I'm not going to loan you any money. I don't care what your problems is because I've loaned it to you 2 times before and you haven't paid it back. Sometimes people view criminal history that way. And when I was a prosecutor, sometimes people would view criminal history that way. They would say, you know what? I gave you probation before, you didn't do well on it, and you pick up another case. I gave you probation the second time, you didn't do well on it, and you pick up another case. So maybe that could be a reason why people make offers that they make.
Okay, let's talk about that loan analogy. Brilliant, right? Think of probation like trust. The court gave you a second chance once, maybe twice. But if you keep violating it, don't be shocked when they stop offering mercy. It's not personal, it's pattern recognition.
But what I want you to take away from this conversation is this attorney, according to the will, is qualified to handle the type of case that you're charged with. And I would tell you one of the qualifications they must have, and Mr. Gomez, correct me if I'm wrong, he has to have tried cases before, and he has to have tried felony cases before. You can't just have tried misdemeanor cases and then come to felony court and say, oh, I'm qualified. That's not how it works. So he's tried the necessary cases. And if you are upset by the offer that he is tendering to you, no, that is the offer that is the state has made. And in this court, I require everybody to treat each other with kindness. So I guarantee you, when the state made him that offer, the state wasn't mean. The state just says, this is the offer I'm making. And I expect you to treat your attorney with respect. I'm sure your attorney will treat you with respect. But again, if you want a different attorney, you need to retain an attorney. So that means you need to go out and hire an attorney. And if you don't have the money to hire an attorney, then this is your attorney. Do you understand? The other thing I want, that's either yes.
And there it is. The judge wraps it up. With a clear choice, accept the offer, counter it, or gear up for trial. What would you do in Mr. Rhino's shoes? Let us know in the comments. Would you take the deal, roll the dice in court, or hire your own attorney?